This commenter right here just explains the reason why landlords need to hire competent process servers to handle their paperwork if they don't know the rules. Hi, my name is Rob Wells. I'm the Landlord War on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos here. Now, this tenant commenter here stated that I guess their landlord left the unlawful detainer summons and complaint, I guess, at the front door. There was a babysitter. They were 17 years old. The babysitter didn't open the door, and the tenant wasn't advised of the hearing date. So we'll unpack those two items together. So first off, when you're affecting service of process with any type of like termination notice or an unlawful detainer, there are certain rules and procedures that have to be followed. Okay, and in the Code of Civil Procedure, there's specific rules as to how a landlord basically or a plaintiff has to serve their paperwork. And generally speaking, a landlord themselves, if this is like an individual landlord was serving their own paperwork, that's improper because a party can't serve their own paperwork under the law. Basically, you have to have a third party person do that. You can have anyone that's 18 years or older serve the paperwork, but many experienced landlords and law offices, for that matter, use registered process servers. A process server is a person that is hired on behalf of a party to affect service of process or to serve people legal paperwork like these summons and complaints. And you can have them hired to do termination notices as well too. There are a few advantages off the top of my head that I can tell you about using a registered process server, including because they have to be registered in the county and post bond, and they're held to a higher standard. They get an evidentiary presumption that on their declarations, they can establish at least a rebuttable presumption, meaning they can at least establish up front that they did service properly as declared in their declaration. Okay, now that always can be refuted, but that could, for landlords, the advantage of having that presumption is you can rebut a challenge of a tenant just saying, you know what, I wasn't served properly. Okay, a tenant's gonna have to bring further evidence to rebut that process server. Okay, so that's one aspect. Now let's go back to this scenario here. Now this landlord, if they tried to serve the paperwork on their own, they're in hot water. Okay, that's not going to be proper. Okay, if you did a little bit of digging in court, that's probably going to get thrown out. But let's talk about what service the landlord was trying to affect. It sounds like they were trying to affect substitute service. Okay, now gold standard in the law is obviously serving the tenant in person, personally, a copy of the summons and complaint, right? But the law does allow for other procedures if a tenant can't be served personally, okay? And one of those methods is substitute service. Now, in the law under Civil Code section, or Code of Civil Procedure section 41520, B, in eviction cases, usually you're trying to make attempts to serve a tenant at the residence, okay? Especially in a residential eviction, okay? That's where tenants are going to be found, and you have to show diligence. Okay, to affect substitute service, the server is going to have to show diligence that they have at least attempted to try to serve a tenant at least 3 to 4 times on average. And I believe this code section is going to be changing in next year, basically, where you're going to have to show geotag data, like when a server goes to the property, that type of deal. I think for registered servers that they're going to have to show like, hey, they were actually there. They're going to have to take a picture of, the premises basically as evidence as part of their filling out their proof of service or summons that requires this information to protect against fraudulent serves. Okay. There's a thing called sewer service, that type of deal where servers will lie on their declarations about service. So, but let's go back to diligence. I went off track. Sorry. For diligence, you usually have to show that you've tried at different times and dates, basically during the day, to show that you tried to get someone served in person, okay? And if they can't be served and that tenant's not there, and let's say someone opens the door, you can effect substitute service pursuant to the code section, okay? They have to be an adult, appear to be in charge of the premises. You serve that person, and then you got to put a copy in the mail to the named defendant or tenant back to the residence, basically. Okay, so doesn't sound like that happened, and that could probably be challenged probably by like a motion to quash or some sort. So the importance of this for landlords is you got to do stuff the right way, and if you're going to do it yourself, you're going to be held to the same standard as an attorney, basically, or anyone else that's practicing in court. So just some thoughts here. Landlords, if you're going through this situation and you're trying to do everything yourself, but you don't know what you're doing and you need some help, like actually doing a case, like, because you're going to have to learn all this stuff here, feel free to reach out. We might be able to help out. Put your comments, questions down below. Try to answer them to the best of my ability. Until next time, folks, talk to you then. See ya.